I can push buttons. This is something. All right. Congratulations, by the way, to all the graduates out there. Um, yeah, we know, especially mini me's out there. We are. It's pretty amazing. It's pretty amazing. Um, it is that time of year in my neighborhood where you start seeing people in like um, prom outfits and graduation dresses mostly, and then about 2 weeks later, all there's this gap. Like nobody lives in my neighborhood that's beyond like from 19 to maybe 30. Those people don't exist except for during the summer. So we do have a lot of different age groups, but we don't have those guys very often. There's no college kids in Whitefish Bay. There used to be a university literally like 2 blocks away. It was Catholic, and it like folded overnight. It was the biggest mill for educator degrees, minor educator degrees. I don't want to say mill in too much of a pejorative sense because it was doing some good work, and there were definitely you want to be a speech pathologist. That's where you were at, and we need speech pathologists. So what the heck? But I'm just saying there's a lot of PhDs that they were churning out pretty close to me, and now I think it's going to be a high school and a religious high school at that. So that'll be an interesting diversity. No, that's not the right word. Change. Who knows what the diversity will be? It's like called Augustine. It's one of those things where they like put up a construction fence, change the name on the logo, and everybody's sitting there being like, we'll see what happens. We don't associate with people from Fox Point and from people from Whitefish Bay, so I daren't gossip with them. All right, enough of inane chit chat here. Let's get right to it. We are in this Poway School District First Amendment case. I quickly Googled here. We can do it, Ben. Except we can't. Okay. Um, which is awesome. I really recommend everybody to check this out. It is your jury instructions for federal court are now online. I think we mentioned that before, and they really explain really all the claims that are out there and the elements of all the claims. And if you really wanted to understand, I mean, it's in fairly plain English. It's the whole point of a jury instruction. It's really fantastic for resource, and I'd say that the United States is better off having with this public than what it was before, which you had to pay a lot of money to be able to get these because they were just printed on paper. Okay. And that was really the government made a decision that it was its business to make it available to everybody, and then it did that, so that it was an improvement. But here we go. Section 1983 claims against defendant in an individual capacity. This is, by the way, the United States Court for the Ninth District. So that says to me, it's just a little bit strange, but that is the Ninth Circuit Appeals Court, otherwise known as California. And so I think we're in the right place. This would more or less be the law everywhere, but let's be clear. Okay. So, in order to prevail on a 1983 claim against a defendant, and this would be literally the jury instructions that you would put in there, and let's say here is the key thing, okay? What is an individual? Is that just a person? That's really what the key fact is. So you're going to have to say, I forgot that we have a doc in the background here, but Superintendent Marion Phelps. That's who you could put in there if you wanted to do that. But so that's what we're talking about. We'll go from there. The plaintiff must prove each of the following elements by a preponderance of the evidence. The defendant acted under color of state law. And, okay, so that's fairly easy to show here. We're talking about, okay, so what's an act that she committed that we will say that she prevented the pupil from being in sports, okay, for this, I think it was the fall. So that defendant acted under the color of state law by preventing the child from engaging in sports. That, no, I mean, nobody else but somebody with state law authority could do that. Key question here, why is it color of state law that matters? Because this is a 1983 claim where you were able to sue somebody for a deprivation of your civil rights. And this is being imposed upon the states by the 14th Amendment. Okay? The act, so we're going again, the prevention of the pupil from attending fall sports of the defendant deprived the plaintiff of particular rights under the laws of the United States. Okay? I think we're going to have to tweak that a little bit here because ultimately it's retaliation is what we're looking at. And I don't know if that's a separate jury instruction. But let's do it more clear cut than that. The defendant's a police officer. The police officer beat somebody up. The defendant acted under the color of law. The beating of somebody up deprived the defendant of particular rights. And then you're going to say which right. So this would be their First Amendment right because basically we're going to do both at the same time. For the pupil here, we're saying that by participating in the softball team, that's a First Amendment act, and by excelling in the softball team, that's also a First Amendment act. Okay, so I mean, and you have a right not to get punched in the face by a police officer, and you guys are going to know that much better than me. Just don't do those kind of cases. But that's clearly a violation of due process, among other things else. I do these kind of cases, I don't usually do violence by police officers. Just because there's almost always so much other things going on. And there's other people who do. Okay. So it does indicate there under number 2 that the law of the United States has to be a constitutional or the Constitution. It's important to remember that not all of the constitutional rights, all of the Bill of Rights are incorporated by the 14th Amendment, but we'll save that for a later date. The important ones are. As explained in later jury instructions, that's probably what's causing me so much pause here. Is I'm looking for that explanation here. And the defendant's conduct was an actual cause of the claimed injury. Okay? Now, hilarious. A person acts under color of law when the person acts or purports to act in the performance of official duties under any state, county, or municipal law, ordinance, or regulation. Let's back that up. Acts in the performance of official duties under any state, county, or municipal ordinance or regulation, okay? So let's keep in mind that being a superintendent is definitely is an act that somebody does in the performance of official duties, okay? So like initiating an investigation would be an act. Now let's say that act is outside of your abilities to do as a superintendent, but you claim that they are. Or let's say that you're just a regular person and you're pretending to be the superintendent for some reason, and that you're depriving somebody of their rights under that, you could also be liable. Okay? That's my reading of that. State, county, municipal law, ordinance, or regulation. Okay? That's fair. The defendant's conduct is an actual cause of the plaintiff's injury only if the injury would not have occurred but for, we remember that test, but for that conduct. The conduct has significant connection to the result. Okay? Let's just read this last thing here. If you find the plaintiff has proved each of these elements, and if you find that the plaintiff has proved all of the elements, the plaintiff is required to prove under instructions, specific, these are the ones we're talking about later, your verdict should be for the plaintiff. If, on the other hand, you find that the plaintiff has failed to prove any one or more of these elements, your verdict should be for the defendant. All right. I want to say the formatting, the font, almost everything about this is the same as what I would expect, but it's different enough that it's it is peculiar in America how everything can vary from, small inches of geography. But that's how we do it. All right. So let's get back to finally what we came for here, which is more allegations. All right. If you'll recall, there are a bunch of pupils, one of which who is competing directly against the superintendent's daughter for the pitching position. And I guess the competition is fierce. There is an awards banquet. Even before that, the superintendent is involving herself and hampering the, I don't want to say no, the competitor from and threatening her and like making her basically, if you don't sign this, then we're going to do this kind of thing. Okay. Then there's an awards banquet, among other things. And at this awards banquet, the superintendent's daughter wins an award. But the superintendent's daughter, it seems like, goes into is upset because she perceives that other people are not clapping loudly enough for her. I want to parallel the parent and the child's behavior and I do not mean to throw shade on a pupil, but I just want to say that this kind of parenting here, where you feel entitled to use your powers as superintendent to interfere on behalf of a child, may induce the child to expect that other people are going to treat them like royalty and be upset when they don't, or even that is not particularly clear. Then the superintendent takes up cause and for her child and starts calling an investigation on her own and calls a pupil that attended this banquet at like almost 11 o'clock at night. I think that's where we're at. The child, let's just say whatever happened in this conversation with the child, and we have those text messages, or some of them, it was absolutely inappropriate for the superintendent to contact a pupil directly, especially at 11 o'clock at night. Poway's Unified School District's investigation. Defendants represented that on June 6, 2023, an investigation began after anonymous complaints were allegedly made against plaintiff for bullying and harassing JP. We are going to do some grammar here on this. I was always taught that these are called scare quotes, and you don't use them in terms of people know what the word people know what the word investigation is, and they also know what the word anonymous is. So unless you're trying to use it in some context here that is outside of the normal sense of the words, that this doesn't. There's better ways to indicate it, like for example, so-called or supposedly, because I think that that's what those quotes are designed to communicate, which is that although they're being styled investigation, they're really an inquisition. And these anonymous claims are not actually that anonymous after all. Okay. Were allegedly made, and see, that's also why. Okay. Made against the plaintiff for bullying and harassing JP. However, we are informed and believe, and that's, we would also say on information and belief. The investigation likely began on the night of the banquet, May 30th, 2023, when yes, I mean, there's no question about that. When Superintendent Marion Phelps text messaged and then called and interviewed M.A., a pupil, and a witness to the alleged events. We are informed and believe that Superintendent Marion Phelps instituted, controlled, and orchestrated the investigation. On June 8th of 2023, Del Norte High School employee interviewed plaintiff regarding the allegations made against her. Plaintiff sought representation during the interview and expressed a desire for her parents to be in attendance. Her request was denied, and the interrogation proceeded without her parents present. During the questioning, plaintiff's parents arrived. During the questioning, plaintiff's parents arrived and asked the lobby assistant several times to be present for the remainder of the session, but were denied. I'm not familiar enough of what a lobby assistant. Okay. So this is the accusation is the school district is interviewing the pupil here, the competitor, without the parents present, although the parents are asking to be present. Again, this lobby assistant thing, but, a functionary. Got it. Several times to be present for the remainder of the session, but were denied. Okay. By the way, we are trying to comprehend this together. I am 5,000% not trying to throw any shade on these attorneys when I make any criticisms here. But there's no question that anybody looks at my complaint, there will be errors. The complaint is just a document that's often written under tremendous pressure, especially time pressures, no doubt about it. But one of the things that we're trying to do is understand it. That's what communication is all about. But I really want to express that I mean, this is not a critique. Okay. Negative critique. The school refused to take testimony from senior softball players, even though plaintiff's parents said they needed to be part of the investigation since they were at the table during the banquet. The senior softball players were all too afraid to unilaterally speak up as their ability to attend graduation was threatened by Superintendent Marion Phelps. That sentence worries me just a little bit, only to the extent that I'm just not clear how they know that. And I would definitely say because Superintendent Marion Phelps threatened them, they may have been too afraid to speak up without the parents. But maybe they know that. What do I know? Plaintiffs agreed to the employee's suggestion of attending a mediation session the following day with JP aimed at to resolve the matter without administration intervention. It was evident from the employee's demeanor and direct statements warning that the administration was under significant pressure, influence, and control, and held allegiances to the Superintendent Marion Phelps and would likely act in a biased manner on her behalf. Okay. The one thing we do need to go back on that I'm confused about is who is this employee? It just says a Del Norte High School employee. I'm wondering why they're not saying that person's name or at least title. I mean, it's possible they don't know who that is, but it seems very unlikely that the plaintiff doesn't know the name. But okay, um, I this is what we were talking about in a different video. That the way that a school district is set up, the superintendent has complete control over anything that the superintendent wants to have control over. In many districts, it's explicitly in the rules. That's what superintendent means. The question really is, who can prevent a superintendent from getting involved in things that they shouldn't be getting involved in? Oh, it's supposed to be the school board. Okay. After that meeting, plaintiff's parents sought supportive witnesses' statements for plaintiff, as only one had been requested or reviewed by the school. I think these guys spent a lot of time on alliteration, and I applaud them for it. A softball player sent a group text to the entire Del Norte High School softball team requesting witness statements in support of plaintiff to refute Superintendent Marion Phelps's false accusations. Superintendent Marion Phelps' daughter, JP, was inadvertently included on the group chat. Oh, well, that's going to not help things. This thing has a very troubling statement in here, which is Superintendent Marion Phelps's false allegations. And maybe I'm not remembering all of this right, but they're saying the investigation started when she called that person. I guess my question is who is the complainant in this investigation? Who's the person that's making the complaint? Is it the superintendent? Because if that's the case, that's wildly inappropriate. For it to be the superintendent's daughter would be one thing. You know, I think normally what a superintendent would do is have a principal or the athletic director that was at that event and talk to them behind the scenes and tell them to initiate the investigation. But, you know, you've already called a freaking minor at midnight. So why not just do it? Who knows? All right. After the text message was sent seeking witness statements in support of plaintiff, Superintendent Marion Phelps removed the Del Norte High School employee conducting the internal investigation from the investigation. She then seemingly directed the inquiry exclusively through her associates, defendant Mike Giami and Janine Ganson, both assistant principals of Del Norte High School, and Ty Eveleth, the new principal of Del Norte High School. Defendant Mike Giami was subject to conflicts of interest and bias as his daughter is the pitcher. And the Del Norte High School is a player and pitcher in the Del Norte High School softball program. You guys cannot make this stuff up. I mean, you could not write this. So I'm sorry, he is a defendant and an assistant principal, and this is not uncommon that there's so many connections between there, but I'm just gonna guess that softball, and remember, because of Title IX, there's only certain female sports, and that softball is a much bigger deal there than it was where I went to school, which probably had field hockey instead. But I don't know. I do know that I've met several people who excelled at softball, and they were extremely into it. But two things last. this word subject to conflict of interest. Conflict of interest has like no meaning whatsoever about anything. I think educators feel that it does, and maybe it did or should have in their world, but it really means nothing. Okay. The real thing is there a rule that prevents somebody from doing it? That's really the only thing. Whether or not somebody's biased, that's a different story. Okay, but this conflict here, a conflict normally means, in at least in an attorney's sense, is that you've got an interest, meaning there's a direct relative, we've gone through this, or some other financial interest, or a client, two clients who are opposed to each other, that you have one client's interest is conflicting with another client's interest, or your own personal interest. That's normally what we mean by that. But we have a rule, an ethical rule that actually has teeth behind it from the Supreme Court against those things. I don't know that a teacher's license can be revoked or a principal's license for a conflict of interest. That's what I want to say about that. Okay. The second thing there is, this is just, if I go to a school event as a volunteer and my children are going to be there, one of the things that I often do is to ask to not be with my children at all because of just this issue here. And you don't, as somebody who's, I have known that way, that situation, I'm sure we both have, either way, where somebody's parent comes in with resources or whatever else that's beyond compared to all the other children that are at the event, and that child, everybody else is eating lunch food, and those kids get Burger King, for example. Okay, everybody sort of knows that kind of feeling there, where it's just like, this isn't fair. Okay, and it's just not good in an educational setting. Even if the fact that you can remember something like that now from so many years back is very evident that it's not for the best. And I just want to say that it's extremely understandable that one would want their children to excel, and we also understand that there's colleges and other things that are on the line that increase the competition. But maybe you shouldn't be an assistant principal then. That's my feeling about that, is if you know you can't handle it, then don't do it. All right. We are informed and believe that Superintendent Marion Phelps was working closely with defendant Mike Giammi to control and orchestrate the investigation. We would probably just go calling her Phelps or the superintendent, and probably call him Giammi. I think it's unnecessarily long, but hey, despite initially agreeing to mediate, I just don't even know what that could mean. Like, what would JP and Superintendent Phelps abruptly changed course and refused to attend the mediation scheduled by the school for June 9th, 2023. If they have a mediation process at the school, more power to them. It sounds like their own thing. And it sounds like sort of a rigged process to begin with. And I guess that's what they're saying. But then the superintendent and her, we'll just leave it at the superintendent, then won't even play along those rules and then take their marbles and go home. Okay. There is a great quote about First Amendment rights, and I know it's talking about an employee, but it's something like, even not getting a birthday card or like a cake can be an infringement on your First Amendment rights. The point is that it doesn't take very much to chill free speech, and This is already kind of shocking here. All right, we are informed to believe that on or about June 9th, the day of her graduation ceremony, softball player PK was compelled by defendant Mike Giammi to participate in an inquiry session. He intimated that any reluctance to join the session might lead to her being barred from participating in a graduation walk later that day. Well, they kind of had to do it then because that's the only thing they had over them. According to PK, they took possession of her phone. Now, I would say straight up, is they somebody other than Mike Giammi? Because that I would like to know. And examined her private discussions without her consent or her parents' awareness. The school's scrutiny of the text message revealed no evidence of a collaborative plan to withhold applause for JP during the softball banquet. Give me your phone or you can't walk. We are informed and believe defendant Mike Giammi erroneously deduced that plaintiff was a participant in the senior group chat when in fact she was not. The inquiry took place just before the graduation ceremony, seemingly timed to exert pressure on PK, leveraging the looming threat of her potential exclusion from the graduation walk. There's no question that they're connected. We are informed to believe that next, defendant Mike Giammi approached M.A., who was already dressed in her cap and gown. He removed her from the ceremony staging area, cornered her in a private room with no others present, and further inquired about the banquet and Superintendent Marion Phelps's actions. I can see why he's a specific defendant. These are acts. He insinuated that she and the senior softball player perhaps shouldn't have been allowed to participate in the graduation walk. Also want to repeat, these are allegations of overt acts, but they're overt acts. M.A. was scared, intimidated, and disturbed by defendant Mike Giammi's actions. Significantly, this encounter was omitted from the investigative report. That's pretty good use of the word significantly because it's significant. I often got chastised for using the word significantly. And sometimes I put of note instead, but I think it's fine. I'm laughing here because this is preposterous. This assistant principal's actions is, let's just say you're in North Korea and you're getting bullied by the leader to go investigate some other thing. It's still even more gross, the fact that your daughter's also a pitcher. Couldn't they have like the assistant principal bully down the hall do it? There was no other assistant principals, bullies available to bully some kids. They didn't have any others at a straight up high school in California. I'm guessing there's a whole herd of them. The only assistant principal they could send a bully there, and I accept that sending an assistant principal to bully a pupil is a task often assigned to assistant principals. But again, my point is why couldn't they have found somebody whose daughter was also not a pitcher? Even in North Korea, you'd think they'd have some. I mean, unless he could be the best bully of them all. That could be, maybe he's the best inquisitor of all of them, hands down. And so it's really not, it's just, it's meritocracy over there. I don't know, assuming these allegations are true. Hey. Following this investigation, the employee compiled a concise report and handed over investigative responsibilities to defendant Mike Giammi. The employee was leaving for vacation, and the plaintiff is informed and believe the employee sent her report to defendant Mike Giammi on or about June 9th of 2023. My guess is they like this person and don't want her name to be in this international news. That's my guess. Got it. She also she called plaintiff's parents that afternoon and said they know who this person, sending her report to defendant. There would be no surprises from her in the report. I don't know if that's something I'd ever want to hear. The employee apologized several times and stated intimidation was not being considered. We are informed by the employee that the official version of her report is not consistent with the report she submitted to defendant Mike Giambi, and that it was changed without her knowledge, permission, or consent. So I think we have that there. Wow. Well, I'm going to pause here and we'll just keep going. Hey. God, like I don't have closing theme music. This is wild in my mind. Absolutely wild. Wow. And if any of you stuck with me, thank you very much. Seriously, hit the like button. What's wrong with you people? Take care.